Welcome back after tea and coffee, ladies and gentlemen. We're in the final home stretch of SREcon Europe 2016. Thank you all for your great attention so far. And now for something completely different, we have your favourite legal entity and mine, Simon McGarr from Digital Rights Ireland. Can you please put your hands together?
I'm going to give you a clap. So Simon's, he has many hobbies. His day job is representing various people who have been wronged by various parties. But his hobby is winding up various government entities who he realizes have gone off the rails, shall we say, with respect to data privacy, data retention, or just trying to collect data they really have no business collecting. But this is a follow-on from a talk we had last year where Europe was rather interested with a European court case that was pending that was going to strike down something called Safe Harbor, which was a fantastic piece of legislation, sorry, not real legislation, an agreement between friends that allowed European and US companies move user data between them out of convenience. Could I get a hand up here for anyone who has any kind of European citizen data that they move outside of the European Union for access reasons, backup reasons, latency reasons? Okay, so you may be interested. Does anyone here use, for instance, a US-based website that might track their password? Okay, that's going to be great. So maybe we could start, and you could tell us how did you get into this interesting business?
Well, so I'm a solicitor in private practice, and one of my clients is Digital Rights Ireland, and Digital Rights Ireland is 10 years old, 11 years old this year, and it has, for almost the entirety of that time, been running litigation. The first court case still hasn't finished, but other court cases have joined it. And so its first major outing in terms of litigation was a challenge to the Data Retention Directive. This was a directive which allowed states to gather up metadata in relation to people's telephone calls, their internet use, their email, and so on. And so this had gone through the European legislative system. It was a full piece of European legislation, and there was a full duty on every country, member state of the EU, to implement it. So in order to challenge it, we took the first ever successful challenge to a piece of European legislation on the grounds of the Charter of Fundamental Rights. And the Charter of Fundamental Rights is a relatively recent addition to the sort of the legislative framework of the EU. It came into force following the Lisbon Treaty, and it sets out what is the human rights basis through the prism of which all other forms of legislation generated by the EU and all actions by the EU and its institutions must be seen and must be measured up against. So the end result was that the Data Retention Directive was struck down as being in non-compliance with the Charter of Fundamental Rights. And we've since taken cases where we have challenged, or rather, we've taken cases where we've challenged the independence of the Data Protection Commissioner here in Ireland. That's still ongoing. But we also became an amicus, and we were joined to the case as a friend of the court, and we made submissions to the European Court in the Schrems case, which was relating to the Safe Harbor Agreement. Mm-hmm. And so
maybe you should discuss the Safe Harbor, what it was, and how it was
sure.
incompatible with European law.
It's difficult to try and run the internet without being able to move personal private data from the EU to the US.
It's almost as if that's what the internet was invented to allow.
It seems to be always presumed that you can move data around the place. It seems to be in the plumbing. But nonetheless, there are issues in relation to doing that between the US and the EU, and from the EU and any other third party. But the US is a particularly large market, and so the EU was interested in coming to an agreement. How will we let this happen? How can this occur swiftly and easily? Now, 12 years ago, they got an agreement between the EU and the US called the Safe Harbor Agreement. It wasn't a piece of legislation. It was a set of letters provided reassuring the European Commission that everything was going to be okay and certain precautions would be taken in terms of private European data. So that was good, and that carried on, and basically was the sort of the unnoticed floor that the internet was built on from 2000, 2002 onwards.
It seems like an omission is that, yes, there was this agreement between the European Union and the US, but there were no other agreements between other countries, right?
This was a particular form of agreement. And there are, of course, other forms of agreement with other countries to allow you to transfer data to India. They allow you to transfer data to other third-party countries. There's also what's known as an adequacy arrangement, where you examine whether or not the country that you're sending the data treats the data with an equivalent amount of care as is required under EU law inside the EU. And there's been findings in relation to some countries that happens. So you can send data to there and back again, and they promise to look after it just as though it was their own. Or more importantly, just as though it was your own. So those kinds of questions don't usually pose a difficulty. The US had a particular case because the European Commission was given the job of deciding did the United States have adequate protections? And that's the purpose that's actually the Safe Harbor Agreement. It's basically just a bunch of letters of reassurance and then a decision by the European Commission. Taking all that we know into account, it seems that this is an adequate level of protection.
It's interesting that that's not legislation, it's not a court opinion.
No, it's not legislation. It's done under a directive, but it's a provision which hadn't really been challenged. And what happened was that the Snowden information became public, and there became disquiet that maybe the basis on which the decision of adequacy had been made hadn't been taken in the fullness of available knowledge that was now here in front of them as to what might happen to European data when it travels to the States. So in the end, the court in Ireland decided that it couldn't decide on Mr. Schrems's complaint about the Irish Data Protection Commissioner. I'll spare you the details. Without sending the matter off to the European Court of Justice to ask whether or not the Safe Harbor Agreement was okay in the light of all that was now known. And did it meet the requirements for adequacy? And therefore, was it in compliance with the Charter of Fundamental Rights, or was it a breach? And the end result was last year a decision from the court that the Safe Harbor Agreement was not in compliance. Now, that has immediate effect. The court makes a decision, that's it, it's made its decision. And the result is that the United States and the European Commission and the member states were quite quickly looking around for something else in order to replace Safe Harbor.
When that court decision came in, we all stopped transmitting data from Europe to the United States.
I know.
Immediately.
Yeah. I'm sure.
Yes.
So what happened actually was that an awful lot of law firms who were not me, who may have said Safe Harbor was a legitimate method of doing it, and of course on the basis of that, the knowledge at that moment it was legitimate until it stopped being legitimate, they said, okay, it's not the only way you can do it. I mean, it's a nice way, but it's not the only way you can do the transfer. There's also a thing called, and then there's a series of other alternative things. And one of them is standard contract clauses. So you get the other side that you contract with, the people who you send the data to, you get them to agree in a contract that they will take care of this data. Now it's written in the contract.
So this would be, for instance, Woolloobaloo Ireland wants to send it to Woolloobaloo in the US, and Woolloobaloo in the US sends them a contract saying, yes, we promise to be careful.
Yeah, if you're sending it out on the basis of standard contract clauses, and these are literally standard contract clauses, these are pieces of verbiage which you plop into the clause, and the Commission has pre-approved that these things are the kind of things they'd like to see in contracts, thank you very much. And so that became the new normal method of doing data transfers between the EU and the US in respect to personal data. There were questions raised about that, and because there is a rationale given as to what an adequate system would look like in the Schrems 1 decision from the Court of Justice in the EU. And reading it, there is an argument that perhaps some of the difficulties that the Safe Harbor Agreement would run into might also might be applicable to the standard contract clauses system. But nonetheless, there'd been no specific finding in relation to standard contract clauses. So that's been the normal transfer arrangement. In the meantime, at the political level, there was a wish to have a thing to replace safe harbour. And so that became branded at the last possible moment, just before a deadline, when there was going to be a finding that there were perhaps no legal basis, or there wasn't a legal basis for continuing to transfer arrangements, as the privacy shield. I beg your pardon.
So this third tower of data transfer
mechanisms. We call them mechanisms.
You could say it's the third tower because the first two burned down, fell over into the swamp.
Yeah, okay.
But the third one, it's going to stand still.
Well, I make no decision on standard contract clauses. I'll tell you why later. But in relation to the privacy shield, definitely there was a wish to have something that would stand in the stead, but be sturdier than the safe harbour agreement. Mm-hmm. And so the United States sent more letters of reassurance, one of them, I believe, from the Office of the President, to the European Commission in respect of what kinds of things could happen to data, personal data, if it landed on US shores, but also in respect of a new issue that had been highlighted by the court, which was the requirement to have an independent data protection authority that you can go to, which is a requirement in the Charter with its own special bullet point number.
That if you feel your privacy is invaded, you can complain to.
And you have an independent body that you can go to.
So if theoretically you suspected perhaps the NSA collected data on you, which independent body would you go to complain about that?
Yes, there are difficulties. So, you'll be glad to hear that one of the arguments used by the United States in promoting Privacy Shield, and again, this is the United States position, is that there are in fact lots of independent data protection equivalent authorities for you to go to. But maybe there was a need for even more of them. And so...
in the European Union, we have 47.
We've lots of them. I mean, Ireland has one, but Germany alone has one for all the Landern, and then there's national ones. The European entities have their own one called the European Data Protection Supervisor. Lots and lots and lots. Why not have lots in the United States as well? But we also have a thing called the Article 29 Working Group. This being the EU, this is how we name things. And it doesn't have a snappy name, there's no branding here. So the Article 29 Working Group is a sort of a very large round table of all the data protection authorities who come together to sort of make sure that they coordinate policy and speak with something akin to one voice, or at least in harmony and not against each other. So there's a suggestion that there be a new entity in the United States set up that you could go to, a kind of an ombudsman who would look into the matter if you were unhappy with how your data had been used, if you felt that there was something wrong. So there are plenty of changes in Privacy Shield. And that was announced, and it will come into force. Oh, they asked the opinion as to whether or not of the European Data Protection Supervisor. How does this look as a deal? Supervisor wasn't totally sure. Thought maybe there might be a couple of things that needed a bit more work. But that's great because you have to ask, but you don't really. So on we go to the European Parliament, and they have to consult with the European Parliament. How does the European Parliament feel? I don't know if anybody saw, there's an article by Jan-Philippe Albrecht, who is the European Parliament's rapporteur on this issue. He's an MEP from Germany, and he was publishing an article with Max Schrems in the Irish Times only this week, saying Privacy Shield wasn't going to be sufficient to protect European data. So that's quite a strong position for the Parliament to have taken. But again, the system requires only that the Parliament has its opinion sought, not necessarily that it doesn't get a veto. Mm-hmm. And then finally, the member states were asked, are you happy with this? And the member state says, we are happy with this. And so it will come into force on the 1st of August. Now, that's interesting. Once it's come into force, there are people in Europe who have previously challenged administrative decisions of this sort. I mean, the article with Jan-Philippe Albrecht was co-authored with Max Schrems, who took the first case. He's the named defendant currently before the Irish courts again in a second case. Because
many other bodies seem to have taken a great interest in this second case. It's not just Max Schrems versus the European Union.
No, in this case, the Data Protection Authority of Ireland sued Facebook and Max Schrems as the defendants in a case, and then a number of other entities, including, as far as I know, for the first time, the United States government, have asked the Irish courts if they could join as an amicus and give helpful information to the courts.
Well,
I represent one of those bodies, the EFF, in respect of this case. And
do they know that amicus works differently in Europe than it does in the US?
one of the joys of being a practicing lawyer is not to try and imagine what's inside other people's heads.
Okay.
People are black boxes, and we just look at what comes out of them. We don't try and imagine.
I know last year that some of the most entertaining and interesting and insightful conversations came from audience questions.
Oh yeah, I love questions.
So, can I ask you to maybe, if anybody would like to ask a question, line up at the mic, and maybe we'll take questions in a couple of minutes. Just want to, get thinking of questions now.
Cool. So, why is the Electronic Frontier Foundation so interested in European data protection law?
Well, in the end, the creatures who are attached to the amicus, who are attached as amicus in Ireland, will be the creatures who become parties before the CJEU. Unless you are admitted to the court in Ireland, you can't make submissions to the court in Luxembourg. And the United States, quite reasonably, thinks that it has helpful information that it can give the court in Luxembourg as to the workings of American law. This case is a follow-on from the first case, and the Data Protection Commissioner of Ireland has written a draft decision as to whether or not special contract standard contract clauses are in compliance with European law. Now, certainly making transfers to the United States. So the United States wishes to have an opportunity to say, there's things we can tell you about what goes on in America and what laws there are in America. We can be helpful in respect of those kinds of things. And the EFF similarly believes that it has useful both legal and technical expertise in the area of surveillance law, but also other forms of US law in respect of data privacy and privacy in general.
Mm-hmm. It's going to be very, very entertaining. Okay, so one of the other court cases that's also ongoing is this case of the US versus Microsoft.
Yes, this is a different kind of case. Here I act for Digital Rights Ireland as an amicus, and our co-counsel across in the United States is White and Case of New York. And this is a case where a local court in New York State made a decision that Microsoft should hand over some data that they had control over to a local prosecutor. And those are the facts of the case. The complication for Microsoft was that the data lived in Dublin. This is a recurring feature for data. It tends to sort of pool in Dublin quite regularly. So the data lived in Dublin, and they had a problem because the request had not gone through what was known as the Mutual Legal Assistance Treaty system, where governments helpfully ask each other to assist in the solving of crime. Rather, this local court had issued an order to Microsoft directly, go and get that, take it out of the EU and bring it over here. And Microsoft said, there's another system, a way of making transfers.
That's legal.
We've got treaties. And the treaty itself was introduced before the Houses of Congress, and it's known as a self-executing treaty. It became part of American law. That doesn't always happen with international treaties. Nonetheless, so far, at every step of the way, the US court system has found that Microsoft is wrong not to hand over the data. Now, this has an issue because, of course, as Microsoft has argued, if it's the case that anybody who's any court at any level can make a court order of that sort in the United States about data held outside, Well, they anticipate, not unreasonably, that any court outside the United States would feel that it too could make court orders in respect of data that's being held inside the United States. And they see this as being a particularly bad precedent to have set. So they're willing to appeal until they reach the point where they hope they have a favourable decision, or there are no more appeals left, as far as I understand it. Mm-hmm. So the matter has been heard, but is in post-hearing chambers, I think is the phrase, where the court has heard the oral argument, and there have been a number of further exchanges in respect of changes in fact, events that have occurred that might have a bearing upon the court's decision, but we don't have a final decision from the court yet. And beyond this court, there's only the Supreme Court. Mm-hmm. Of the United States.
It's curious. I'm trying to work out if they decided to do that, would the only way to defend against that position then be that data in Europe must not be accessible by any US-based employee or something?
Well, I mean, look, if you were going to design a system whereby you were going to avoid this legal dilemma, what you would probably do is you would break your company into three parts. One would be a holding company, one would deal with the United States, and one would deal with the rest of the world, and you would move the holding company and the rest of the world into the EU. If you did that, that would mean that you could not any longer have an argument before the US court that the actual controlling entity was within the jurisdiction of the US court.
Speaking as an SRE, I'm grateful that doesn't require technical work.
I also want to just probably clarify on Simon's behalf, that's probably not legal advice.
No, no. Though if you work for Alphabet, formerly Google, you might think about whether or not it maps quite handily onto that proposal.
So maybe Niall.
Shout.
I'll shout. Thanks for coming back, Simon.
Hello.
I guess the question is it's back. Excellent. Question is, you were going to tell us why you thought that standard contract law would not be of much utility in this case. My guess was going to be that Wallabaloo Limited was not in any position to guarantee necessarily what happened to the data on the transit path between the two.
Well, certainly that's one of the issues that the European Parliament raised, where it's concerned that you can certainly sign a contract between two private entities which promises that you will treat your data in a certain way, but if one of the entity lives inside the United States, that it's also susceptible to all the United States laws, including any laws which would require it to hand over the data to a government entity. And so that's one of the issues that was identified by the European Parliament.
But there is also a second part of this around a more informed consent being required.
Yeah, I mean, look, the gold standard of data transfer is informed consent. If you actually tell me, Simon, I need to move your data to the United States, and I say, what are you going to use it for? What's going to happen to it when it gets there? What are all the things that could occur?
We'll mind it, but law enforcement agencies might be able to get at it.
If you give me full information so that I can understand exactly what actually will happen personally to my data, not generally, but personally to the data that you've collected in respect of me, then I'm in a position to give informed consent. And I can say, yes, I now understand those things can happen and I'm okay with it. And that's the gold standard for data transfer. It's also extremely difficult because you have to do it individually, person by person. I have no doubt that it's within the capacity of the room to come up with some way of doing this en masse. But the reason it's not generally used for data transfers is once the data travels to the place, before that happens, I have to know everything that can and will and did and does happen to it, and nothing that I wasn't told about can happen to it.
And be able to explain that to your average user.
To an average user, and I'm below average when it's going to come to technical matters, and I'm still going to struggle by the time I've come to the list. Hello, a question. I love questions.
Yes. Waiting for the microphone to turn on. There we go. Does that include having to tell someone that they might be subject to, at some point in the future, being subject of a national security letter, or does it mean that you have to tell them if we get a national security letter?
Well, you'll have to say that this is one of the things that can happen, but further than that, what does that mean? What happens to my data when that occurs? Where does it go? Who has it? Is it copied X many times? Who gets access to it? Where is the independent data protection authority that I can go to complain about? I really need informed consent. And I'm not sure whether or not all
And
the...
if we aren't told that either, hypothetically?
Oh, well, that seems quite difficult to do in that case.
So are there any other questions? Otherwise, I fear I'm going to have to...
There must be more
There must be
questions than
more.
that. Come on, in fairness.
Otherwise, me and Simon are going to talk about the complicated legal jurisdictional battles that will happen with Pokemon Go Pokemons as they're brought across the Atlantic.
Is your Pokemon Go score personal data? I don't know about that. It does have GPS elements.
I was going to
so
say,
I think
if
it
it's
probably
recorded
does, yes.
everywhere where you've been.
Yeah, I think definitely it does, yeah. But I doubt that is a useful piece of information for you.
I'm just waiting for the first court case, though, when somebody's Pokemon Go records have been sought by the court.
It'll show where they are.
Yeah.
More regularly, there have been divorce cases, I suspect. That's usually where the location data is being sought. People want to know where you were at a certain time. Let's check the old Pokemons.
That took a very negative turn very quickly. Moving swiftly on.
This is what happens when you invite a lawyer in.
Does EU data protection law contain a general exemption for law enforcement, and could these spooky three-letter agencies sneak through that gap?
No, it doesn't. Because, and we know that because the Data Retention Directive was struck down, and its purpose was law enforcement, and it was struck down as being still disproportionate. And so you can't simply have a blanket. If it's the police who want to use this information, then that's okay. It must still be proportionate for the purposes for which it is being used.
Yeah.
So, I mean, it's an obvious first question, but that doesn't mean that's not a good question, because it's one of the things people will go, oh, what about this? No. Still the question of proportionality and necessity come into play. It has to be both.
Basically, we have to blame the Stasi.
I mean, if you want to look historically, yes, of course, there is no doubt that the European Union's opinion on privacy is informed by the experiences of the European states during the course of the 20th century, which were not perhaps of an unalloyed joy, and certainly in relation to state intervention and interference with your private life. There has been a good deal of experience as to how that works out across Europe, both Eastern Europe and former places during World War II which were occupied, and all of those countries have come to a fairly considered decision that they don't like the idea of a surveillance state having had a look at it. Or
So before we accidentally invoke Godwin's law and lose the internet into a legal quagmire, we should take another question.
More question.
Isn't it problematic that like the European Parliament, or generally like also the German Parliament, just goes on and make this privacy shield or other laws, and you have so long to get the verdict from a jurisdiction to get it evaded this law? Like with privacy shield, like you got the verdict that isn't good enough, and they go just, oh, here's another thing like privacy shield and it's good. Like you have so long to get a verdict, and they just make a new law.
Oh, okay. Lawyers are used to traveling on a different sort of time scale. It's not quite geological, but it's definitely not the kind of speed that the technology industry is used to. 10 years is a new case in law. 20 years is a recent case. When it gets to kind of 100 years, we're feeling that's now settled. And so a case that happened only a decision that happened only a year ago, 2 years ago, the fact that we aren't seeing a turnaround instantly, it's not unusual, and we certainly don't think that it's the kind of thing that there has been a failure. Have I failed to answer your question correctly, however?
Not that it's so long to get a verdict, but like that the Parliament just goes on and makes another law that in its core is the same as before.
I think you're asking, if Privacy Shield is shut down, will they come up with another one? And if that's shut down, will they come up with another one, and we just keep ambling on?
There are institutional difficulties in relation to that if you were to decide that you would do that. One of the institutional difficulties is that day in and day out, the European Commission must appear before the CJEU, who can hold it answerable. And if it were to appear, which is probably not going to be the case, bear in mind they did spend the best part of a year struggling hard to try and come to an agreement on the Privacy Shield. And they said that they had in fact been starting this a year, 2 years earlier than that again. So this wasn't done overnight as a stopgap. Nonetheless, if it was the case that the court felt that there was a contempt being shown for its decisions, that they simply were being ignored or were deliberately perverted by the European Commission or the other entities, I think the court would not be behind the door and letting its feelings known about that, and there would be consequences if it became clear that that was an intention. I don't think that that's actually going to happen. The CJEU is considered to be an extremely weighty part of the EU institutions, and its word on what is lawful and not lawful is taken as being the last word.
Okay. You mentioned personal data. How can you define personal data and what counts as personal data?
Yeah, there's a definition in the Act, and personal data is data which is identifiable to me, it identifies me, or data which, when taken with other data, would identify me if the two bits of data were brought together. And that second little bit turns out to cover quite a lot of information. So, Google Maps knows where I live, but it knows where I live only as a sort of a moving point. But if you combine it with its knowledge of how many times do I Google for my own flipping address, it could work out, both know where I live, but then back from the Google Maps, it could work out where I've been as well. So that's all personal data, whether my name is attached to it or not. So personal data actually covers more than you might think because of that element where if you can combine it with other data. It's what causes the health sector so much difficulty when they're trying to anonymize your symptoms and produce anonymized blocks of data. Because of course, there's only so many ways you can get sick and fall over dead. And when you're dead, that's okay because all your privacy rights die with you. That's no problem. But if you don't actually die, you can actually have quite an identifiable piece of illness, and they find it very difficult to anonymize that for that. A gentleman in the red shirt.
Kurt.
To add that, in a previous conversation with a data regulator, I think the phrase something like, could you avoid storing IP addresses on your routers because they could be considered personally identifiable information? And obviously we had to explain that, well, the routers do need the IP address so they can get the data back. So they grumbled and said, okay. Then
but IP addresses are a live issue before the courts as to whether or not they're personal data, and currently the best I can say to you is that the courts appear to be the answer is sometimes.
Kurt.
Would you care to comment on how Brexit might affect this?
I've been waiting for somebody, Janie. Okay, so the great thing is, one, is this going to happen? For the purpose of the conversation, I'm going to have to pretend that it is.
It would be a very boring conversation.
Yeah, okay, I just say no, it's the same. Okay, so if Brexit is going to happen, what are we going to do? Well, okay, let's say the United States, the United Kingdom has now left the EU, whichever part of the United Kingdom that is at that stage, and so such as the kingdom as remains united is now outside the EU, and it is now a third-party country, just like the United States. As a third-party country, it now no longer has the benefit of the member states' presumption of legality and so on. But if it has some sort of access to the single market, which appears to be something that they're interested in doing still, who knows, they therefore have to sign up to the acquis, which is the bank of all the European laws that we keep in a big box. So they have to say, yeah, we will promise to be looking after the data and we will be very good with the data. Problem, you don't get the blank check that the member states do get, and so you have to be examined for adequacy. Are you actually, now that we look at you?
What's this GCHQ thing?
There are some questions here. I see there's a regulatory Investigatory Powers Act is sitting on your books. In fact, the Prime Minister is the person who brought it in, so we can presume that it would remain on the books. Difficulty. If it turns out that after an examination of the books and a bit of a think, in Brussels, for some reason, maybe the European Commission decides that there isn't an adequate protection for personal data, EU citizens' personal data, when it travels to the UK, then it can't travel to the UK. Now, that's bad if you run a bank or an insurance industry out of London or London. So that's going to be actually a bone of contention between the EU and the US and the somewhat UK in the future, I imagine.
Will Privacy Shield, does that also work for Norway?
No, Privacy Shield is specifically only with the United States.
No, I meant between the European Union and... Is it between the European Union or between the EEA?
I'm hoping that one day I can get to my life end without knowing about Norway's position on data protection. I have to say it's not looking good, but right now I don't know the answer.
Okay. It just occurred to me, if the UK did leave the EU, they wouldn't have they may not have a Privacy Shield, and they would have a pain in the ass.
They won't have Privacy Shield. They won't have the benefit of Privacy Shield because they won't be one of the signatories, because the signatory will be the member states of the EU.
Right.
And I don't believe that the EEA includes that. However, Norway would still have to behave as though it was bound by Privacy Shield and it couldn't do anything to the data that arrived into it, because it has to follow the box of laws that we keep in the back.
Great.
Okay, so Vashal?
So my question is, suppose I get data from a user, and suppose that user happens to be in the United States, but he may or may not be a European citizen, who may or may not be sending information originating from maybe Asia, and I don't know any of that because I can't possibly ask him for his citizenship information because I'm not allowed to have that. Which kind of...
Where's the data living?
I don't even know at that point.
Oh, no, you do.
So
it's living somewhere.
Yeah, so it might be living somewhere,
yeah.
But what's really low here?
Well, if none of your sequence of events includes the EU, then it's of no interest to the EU and its laws. But if one of the parties that you mentioned there is in the EU, whether it be the person or the person's data, then it engages the EU legal system.
And of course, that person doesn't need to be an EU citizen as long as they are in the EU. So an American citizen has EU human rights, for instance.
Because, well, they're fundamental rights. They're rights that fall upon human beings as humans who are within the EU system. That's why, for example, the people who are refugees can fall upon the Charter of Fundamental Rights. There's a whole section in relation to that you're not allowed to kill people just because they're not holding a maroon passport. Although I believe that was one of the arguments in Brexit, that was one of the risks. But nonetheless, EU law's remit runs across the EU. That's where EU law works. But data really does live on individual machines. I know you don't like to think about it, but it really does. And if Microsoft can tell me that it's sitting in Dublin and it's a piece of data and it lives in Dublin, I'm pretty sure everybody else here, I'm sure, you know better than I do, but I'm pretty sure if you really tried hard enough, it's sitting on an actual hard disk spinning around somewhere like that. Or what do those solid disks?
I don't think you can comment.
What did they do?
SSDs.
Oh, the SSDs. Yeah. They don't spin around, they just sit there, but they look kind of knowing.
Yeah.
And so, I don't know, I'm not sure what they actually do. They magnetize meaningfully.
Owen.
Just to talk a little bit about the EU interpretation at a local level, as we're here in Ireland, and as a sort of recent father, can you comment on the education of Irish lawmakers and Irish bureaucrats, particularly around things like the schools database, and have these cases helped in educating them to more data protection, and what is the state around some of their learnings or not learnings?
You're going to indulge me, is what you're saying. Okay. So look, in Europe, there was a case recently called the Barra case. The Barra case is a case in relation to what are the powers and limitations of governments in the EU to take data relating to their citizens and then share it around between their various entities. So, okay, I collected my data in relation to social welfare from you here, but actually it'd be really handy if I could give that to revenue to have that, let them have a look. So, finding, no, not allowed. Not allowed unless you told the person, again, back to the informed consent principle, what's going to happen to the data when you hand it in. So this is a thing on which a number of European database projects have either come a cropper or will come a cropper in the future, I suspect. One of them being the obvious one being the data sharing in the NHS in the UK, though that may be solving itself. And if that's to be termed a solution. But we had a similar one here where we said we'd collect the data on children as they go into the schools. And maybe we'd share, once we had a big database consisting of all the young citizens of Ireland, well, that'd be handy to give to social welfare, and maybe it'd be handy to give to this other entity, and we'd store it on the Revenue Commissioner's web servers, or their servers, and so on and so forth. And it turned out that the state hadn't really absorbed the facts of the Barra case. And similarly, there's currently a proposal in Ireland to have health identifier numbers where we're all given like a parallel set of numbers, because the first set of numbers have regulations as to how you can use them. They're the PPS numbers. So the idea is to produce new numbers that don't have any regulations, this being how a bureaucratic mind works. And so these new numbers are going to be used, and then they're going to be pinned to our health records. And then maybe the suggestion the health records would be shared around in the HSE and shared around between hospitals and doctors. That all sounds great. Who would object to that? And then maybe there was an idea that maybe they'd be shared with researchers. Who are the researchers? Well, maybe they're pharmaceutical companies, and they'd get access to the entirety of...
Who are paying for access to...
Well, I presume they'd have to cover the costs. And so the population of Ireland would have their health records perhaps accessed by other parties and so on. And this again looks like one of these projects where perhaps the end thinking hasn't been reached yet as to whether this is something you're actually allowed to do. So the state is very good at coming up with ideas, but perhaps that thinking it through to the bit where they go, and are we allowed to do this? That hasn't happened yet as a habitual activity. I think that probably in the future in Ireland, there has been a kind of a series of unhappy events from an administrative point of view. And eventually they're going to go, wait, will we be burnt if we do this? If I touch this hot thing, will I burn? And someone will go, hot things do burn, I was here last time. And we should not touch it. Or at least maybe we should ask people if we should touch it or not. So then we may see people getting legal advice before they decide to launch national databases. I don't know, it hasn't started happening yet, but I'm hopeful for the future. I'm a natural optimist.
So we have heard that possibly the best solution to solving all these problems is just if everyone were to instantaneously die, all the privacy issues would go away.
That's a total solution. That's a 100% solution.
That seems extreme to me. Can we take perhaps just a final minute?
If we have enough robots, that's it. We can solve this.
Could we take a final minute to wrap up, and then stay in your seats, please, and we'll bring Theo on. But a final minute to wrap up.
Well, I'm gonna put forward the idea. There's another question. Go on, one more question. Go on. They can't stop us.
So storage of private data. Does it matter who owns the server, or does it matter who stored the data on the server? Which one of those matters? So for example, if you're storing private user data in their browser, in local storage, you're storing the data on their disks.
Are they in the EU?
They are when they get off the plane, and then they leave, and then they come back. But you can't enforce the security policies of how that data is because you don't own the system.
Would you have access to it?
Well, you wrote the data there.
Well,
you must have had access to it.
Okay, so you had access to a bunch of data that happened to live on their computer, but you had access to it while you were there.
The idea of when I visit a site and I take part of the personal data that I'm storing with the system, and for efficiency's purpose, the system tells me to store it locally on my disk.
Yes.
Browser local storage.
Yes. And that's in their computer, but you have access to it.
It's very hot. Who needs to think about not touching it?
I would say that everybody who has access to the data has questions to answer as to whether they're a data processor or a data controller in that circumstance. It sounds like the person who made the request to the computer to store it on their local machine is a data controller. But I fear I might burn the minds with tedium of the audience were I to go further than that in the answer. But it looks to me like the person making the request of the user's computer has become the data controller in respect of that data. And therefore, if they are in Europe, has issues to answer.
Simon,
I don't even know why that might be helpful to tell you, but maybe it's all meaningful to you, I don't know.
Once again, you've proven to us this year that calling on legal is not necessarily a sentence of doom. So thank you very much indeed.
I don't know about that.
Ladies and gentlemen, Simon McGarr.
Thank you all very much.